Next on the agenda, we have a presentation on dispute mitigation and resolution. So with that in mind, I'd like to welcome to the stage Scott Lambert, Regional Head of Construction and Infrastructure at Tamimi Company. Thank you, Scott.
Thank you. Good morning, everyone. The topic I'm going to talk about this morning hopefully will give some food for thought and also tie into what's been heard in the last two sessions in particular. The dispute mitigation resolution, what I'm going to be looking at is going to be some contract issues, contract administration issues and forum issues, ways in which disputes can either be prevented in the first place, possibly, or how they can be managed better than what they are currently. At the basis of everything is time and money and time. That's the cause of almost every single dispute. And it's how the contracts are drafted, how they are administered, that end up with people having fights over time and money. One of the basic principles that I always try to look at when either drafting an agreement or negotiating an agreement is that the person who is in the best position to manage a risk should bear that risk. Now, that is something that is important because when a person is asked to bear a risk that they cannot manage or have little ability to manage, there is likelihood that there will be a dispute that will emerge when things go wrong. They may have priced it, they may have thought they could have managed it, they may have not read the contract properly, and they suffer a loss. They'll look to try and recover that through some other means. So the most important thing, start off with contract formation. It's getting the tender right. What really needs to happen is that there has to be a good investment up front before the project goes to tender. I think there's insufficient time and money spent at the currently on deciding the procurement strategy, getting the design right, and getting the tender documents in order. What you see is that, for example, I saw one project recently. It was essentially an EPC of a major piece of infrastructure with a operator maintain period of 5 years after completion on a red book, a construct-only red book, unamended. You can only see that that is going to end up with some pain later on. You can look at what's been mentioned is that, is the project one suited for construct only? Is it something that's more suited to design and build? Could we look at other contracting structures like early contractor involvement or ECI, where you actually have the a contractor on the design team early on to look at buildability issues and resolve those to minimise risk of variations later on. With the tender, also then once you have the tenders in, the lowest tender may not always be the best tender. A project is a relationship. The cheapest, so it's you're looking at a life partner, of course it's like a marriage. The person that's the cheapest date may not necessarily be the best person to have a relationship with. Where you do have a low bid, often you'll then be struck with aggressive variations, contract administration later on. Look at what the contract documents are when you're preparing the contract. Don't get into a situation where you have unintended consequences. One project I was advising on, or the contract I'd been advising on, I'd had the contractor's offer as being the highest priority under the contract agreement. And the contractor's offer, they included it with a set of terms and conditions that the contractor had put in their tender. So those terms and conditions overrode the terms and conditions that the client thought they had, including payment timeframes. And that then was leading to dispute later on when the contractor was insisting on being paid early. The use of letters of award, letters of intent, can often cause difficulties. The problems with letters of award, letters of intent, is that often they are written in the form of a letter they're not written with a strict contractual purpose in mind. And they're not written with precision. They're written, particularly most of the time, by non-lawyers. But they are intended to have contractual consequences. A lot of projects here, the formal contract never gets signed. It's the letter of award that everything is based on. Yet, I say, the language is informal, there's ambiguity. When you have ambiguity, you'll have a mismatch of expectations. The mismatch of expectations will lead to the potential for dispute. Then we look at the contract terms themselves. Some issues there. The risk allocation is always important. Time again we see the risk of delays being limited, being restricted. The penalties for delay damages being quite high. A failure to certify on the part of the engineer to certify any extension claims can then lead to confusion and dispute as to what is the entitlement of either party regarding any delay damages, or what is the time for completion, because the engineer might just be refusing to certify claims for extensions of time. We look at the variation risk. You see in there that often now there's provisions where if the employer or the engineer asks for a variation and don't describe it as a variation, and the contractor doesn't come back within 24 hours or 2 days and say, excuse me, this is a variation, we're going to have to make a claim for an extension of time or for payment of more money, then the contractor's time barred. That sort of provision, which is really a gotcha provision, can only lead to disputes down the track. Similarly, there's the provisions where which are a common contract amendment that I'm seeing more and more, is where the variation is to omit. And the clause has been changed to allow the omission to be giving work to others. So the employer can then cherry pick through the bill of quantities, decide where work can be done cheaper, omit that work and have it carried out by others. Another recipe for dispute later on. Design risk. Design risk is often allocated inappropriately. Even construct-only contracts, you will see design risk clauses being put in particular conditions. You'll also have clauses such as we provided you with all the site information, details, etc. regarding this project, but you can't rely on any of this whatsoever, even though the contractor has actually relied upon it for the purposes of the bid. Rather than making sure that these documents are accurate and in order, they just simply disclaim responsibility for them. Another area where I see dispute. And time bars. Time bars throughout the contract documents. There's time bars for the general time bar normally, then there could be the time bar I mentioned for variations, another time bar for claiming extensions of time. One in particular would be that I often see is that for claiming extension of time, that delay actually occurs. There is you have to give an initial notice to say I've been delayed and claim then within a certain period after that. If you don't give both notices, then you're not entitled to an extension of time. Very unfair. Are time bars necessary? I know there's questions about whether they're enforceable or not. The time bars, and I've seen some standard form contracts in other countries where time bars don't exist. The consequence is if you don't actually achieve a time which is agreed in the contract, then the other side's entitled to damages if they suffer any for that delay, but the claim is not barred. It's certainly most probably a more reasonable position. Some of the problem areas, they've certainly been identified earlier about paid when paid, slow payment and insufficient rights. Certainly in a tight market, and I'm seeing an increase in projects which are heading towards dispute rather than actually in dispute at the moment. But paid when paid is common within the industry, often without obligations on the contractor to actually pass through or to support the claim of the subcontractor. And that can, those rights can cause areas of concern. The slow payment is certainly an area that's a problem, particularly with the last claim. I mentioned earlier slow certification. That's of variations, of time claims. That's one of the major areas where I see stress being placed upon the employer-contractor relationship. And also the retention. It's been mentioned earlier about the level of retention, 10% for a bond, 10% for cash retention, certainly a lot higher than in most other regions. But then there's not only the level of retention, it's the slow release of retention. There are solutions to some of these problems as well. Good faith is part of the law of the region. Maybe it should be expressly stated in the contract so that the parties it's brought to their attention up front. We are to carry out this project in good faith. We are to act in good faith. It's just good faith in how we form the contract, good faith in how we carry out and perform the contract. Early warning provision is quite common in some jurisdictions that both parties, not the contractor, both parties will give the other early warning when they become aware of something that may impact the other party, may impact the cost of the works, may impact the time for the works. That's a collaborative clause of that nature. Also, open book is something that can also help with developing a greater sense of trust. Because a lot of these clauses at the end of the day, when it comes back to it, shows a degree of distrust between the contracting parties, rather than one where they're both seeking to work together to achieve an outcome. The first barrier for a dispute will be the engineer. Because the engineer makes the initial certification, makes the initial determination. Projects that have a good engineer who both the contractor and the employer have faith in are less likely to head into dispute. The more the engineer is the employer's man, even still employed in the direct employment of the employer, the less likelihood there will be trust from the contractor. The more likelihood there will be unreasonable or perceived unreasonable determinations which will lead to dispute. If you have an independent engineer who is respected, has appropriate qualifications, then you're more likely to have a project that will run smoothly. One solution that I've seen adopted on some projects is for the engineer to actually be appointed just not by the employer, but under a tripartite contract, so appointed by both the contractor and the employer, so that there is duties to both parties. Of course, the engineer would still have to retain some areas where they would be the agent of the employer, such as directing a variation, but when it comes to any determination, certification or assessment, they would act independently. Then, when we come to the contract itself and contract administration, the contract should facilitate the administration of the contract. Too often I see contracts where not enough thought has been given to their preparation. It's the standard form or the usual document rolled out time and time again. I actually received a request to review a standard form contract just the other day. It had 55 pages of particular conditions, but it was considered to be the standard form. Those conditions, some of them totally inappropriate. You have to look at what the project is, the sophistication of the employer, the sophistication of the contractor. You may not want all of the reporting that is necessarily being asked for. There'll be some which require monthly reports with safety elements, with time elements, photographs of the project, forward budget, and it goes on and on and on into the level of detail. Is that detail required for the project? Because are the people actually going to use it? Are they going to manage it? Is it just going to increase cost? Certainly the use of electronic systems helps improve things. There's vendors outside, you can talk to more about those. They mentioned about modelling earlier. Certainly that's something which I see as an area where disputes can be minimised, because if a project is properly, or a model is properly implemented in a project, then there should be fewer variations and fewer extensions of time. I know that there's some contractors who have own parts of their supply chain. They will use modelling internally because it's a way to minimise conflict between divisions. Projects I've been involved on, I've seen the effects of where parts of it have been modelled and parts haven't. In one project in particular, there was the element which was modelled, which was about 30% of the project cost, actually came in on time with no variations. The rest of the project was 20% late and 30% over cost, which didn't use a model. So I'm certainly a fan that that should be adopted and contractually required. The issue of then different expectations or understandings of recollections are also an area where there is a problem which can cause a dispute. And also that if you do have a dispute, a lot of the time it will only be several years later that it's going to be heard. So record keeping is important, and accurate records, because if they're made contemporaneously, it can help resolve any issues which emerge straight afterwards, but also protect later on. So having proper records of minutes of meeting, proper records of conversations, making sure that instructions are in writing. If there is an instruction that's given that's not in writing, the contractor should look to use a request for information or request for confirmation back to the engineer. Make sure that there is that paper trail. Just coming back to then the forums. We've had the first forum is the engineer. The engineer makes their determination. After that, depending upon the contract that you've agreed, often you'll have negotiations, and that process of negotiation to be in good faith. That's always a good process. Hopefully that people will understand that once you leave the negotiation process, you are handing the decision of the dispute to someone else rather than the people who are sitting at the table. Dispute boards, adjudication, it's often left in contracts, but very, very seldom implemented. The big problem there is that while their decisions might have some legal impact in other jurisdictions, only arbitration is recognised here. So then the question about arbitrate or litigate, make sure that your forum is clear, that you choose wisely as to what arbitration rules you want or what court you wish to end up before. One thing that's emerged in other countries is for quick or rapid form adjudication of disputes. It certainly has reduced the degree of arbitration, the timeliness of payment is improved, and cash flow is improved, leading to a more vibrant construction sector and less reliance on security and retentions. So for the future, looking at protected payment terms is a possibility. It's something to be discussed. I can't see it happening in the near future. Protected rights to protect. There I'm referring to that often I see employers will have removed the contractor's right to suspend or the contractor's right to terminate. It might be out of the contract, but there is still ability at law under the Civil Code to suspend in certain circumstances, and also there will be an ability at law to terminate in certain cases. It's just that it will be unclear. If you have a fair and balanced approach to it, set it out clearly in the contract, then people will understand when and what their rights are, and you won't have ambiguity, and less ambiguity, the less likelihood of dispute. And finally, a cultural change. Hopefully we'll see it as talked about earlier, and that is where we become a more cooperative environment, one which does focus more on relationships, working together to achieve an outcome, rather than lowest bid adversarial contracts, which will often then result in either party or both parties being dissatisfied. Thank you very much. I've made that with 15 seconds left. Are there any questions? Yes.
There is a lot of talks about the new proposed insolvency law, and it will change the relationship between the contractor, client, and consultants. Are you studying this, or do you think there will be an impact, or how do you feel about it?
Okay, I don't feel that it actually will have that significant an impact on the relationship, other than maybe the form of security which is being taken, because right now the post-dated cheque is seen as one which can be used as a severe hammer by the employer, and that will be a less aggressive weapon that's available there. I think it's more of a cultural issue to do with trust between the employer and the contractor, which needs to change. With that trust changing, you'll get better payment terms, you'll get less need for, the amount of retention and security should reduce. But until there's that cultural change, I don't see it happening. Any other questions? I won't hold you up any further from your coffee break, and thank you very much.